Chapter 2, Actual or Compensatory Damages. Article 2199. Except as provided by law or by stipulation, one is entitled to an adequate compensation only for such pecuniary loss suffered by him as he has duly proved. Such compensation is referred to as actual or compensatory damages. Article 2200. Indemnification for damages shall comprehend not only the value of the loss suffered, but also that of the profits which the obligee failed to obtain. Article 2201. In contracts and quasi-contracts, the damages for which the obligor who acted in good faith is liable shall be those that are the natural and probable consequences of the breach of the obligation, and which the parties have foreseen or could have reasonably foreseen at the time the obligation was constituted. In case of fraud, bad faith, malice, or wanton attitude, the obliger shall be responsible for all damages which may be reasonably attributed to the non-performance of the obligation. Article 2202. In crimes and quasi-delicts, the defendant shall be liable for all damages which are the natural and probable consequences of the act or omission complained of. It is not necessary that such damages have been foreseen or could have reasonably been foreseen by the defendant. Article 2203. The party suffering loss or injury must exercise the diligence of a good father of a family to minimize the damages resulting from the act or omission in question. Article 2204. In crimes, the damages to be adjudicated may be respectively increased or lessened according to the aggravating or mitigating circumstances. Article 2205. Damages may be recovered 1. For loss or impairment of earning capacity in cases of temporary or permanent personal injury. 2. For injury to the plaintiff's business standing or commercial credit. Article 2206. The amount of damages for death caused by a crime or quasi-delict shall be at least 3,000 pesos, even though there may have been mitigating circumstances. In addition, 1. The defendant shall be liable for the loss of the earning capacity of the deceased, and the indemnity shall be paid to the heirs of the latter. Such indemnity shall in every case be assessed and awarded by the court, unless the deceased, on account of permanent physical disability not caused by the defendant, had no earning capacity at the time of his death. 2. If the deceased was obliged to give support according to the provisions of Article 291, the recipient who is not an heir called to the decedent's inheritance by the law of testate or intestate succession may demand support from the person causing the death for a period not exceeding 5 years, the exact duration to be fixed by the court. 3. The spouse, legitimate and illegitimate descendants and ascendants of the deceased may demand moral damages for mental anguish by reason of the death of the deceased. Article 2207. If the plaintiff's property has been insured and he has received indemnity from the insurance company for the injury or loss arising out of the wrong or breach of contract complained of, the insurance company shall be subrogated to the rights of the insured against the wrongdoer or the person who has violated the contract. If the amount paid by the insurance company does not fully cover the injury or loss, the aggrieved party shall be entitled to recover the deficiency from the person causing the loss or injury. Article 2208. In the absence of stipulation, attorney's fees and expenses of litigation other than judicial costs cannot be recovered except 1. When exemplary damages are awarded. 2. When the defendant's act or omission has compelled the plaintiff to litigate with third persons or to incur expenses to protect his interest. 3. In criminal cases of malicious prosecution against the plaintiff. 4. In case of a clearly unfounded civil action or proceeding against the plaintiff. 5. Where the defendant acted in gross and evident bad faith in refusing to satisfy the plaintiff's plainly valid, just, and demandable claim. 6. In actions for legal support. 7. In actions for the recovery of wages of household helpers, laborers, and skilled workers. 8. In actions for indemnity under workmen's compensation and employer's liability laws. 9. In a separate civil action to recover civil liability arising from a crime. 10. When at least double judicial costs are awarded. 11. In any other case where the court deemed it just and equitable that attorney's fees and expenses of litigation should be recovered. In all cases, the attorney's fees and expenses of litigation must be reasonable. Article 2209. If the obligation consists in the payment of a sum of money and the debtor incurs in delay, the indemnity for damages, there being no stipulation to the contrary, shall be the payment of the interest agreed upon, and in the absence of stipulation, the legal interest, which is 6% per annum. Article 2210. Interest may, in the discretion of the court, be allowed upon damages awarded for breach of contract. Article 2211. In crimes and quasi-delicts, interest as a part of the damages may, in a proper case, be adjudicated in the discretion of the court. Article 2212. Interest due shall earn legal interest from the time it is judicially demanded, although the obligation may be silent up to this point. Article 2213. Interest cannot be recovered upon unliquidated claims or damages, except when the demand can be established with reasonable certainty. Article 2214. In quasi-delicts, the contributory negligence of the plaintiff shall reduce the damages that he may recover. Article 2215. In contracts, quasi-contracts, and quasi-delicts, the court may equitably mitigate the damages under circumstances other than the case referred to in the preceding article, as in the following instances. 1. That the plaintiff himself has contravened the terms of the contract. 2. That the plaintiff has derived some benefit as a result of the contract. 3. In cases where exemplary damages are to be awarded, that the defendant acted upon the advice of counsel. 4. That the loss would have resulted in any event. 5. That since the filing of the action, the defendant has done his best to lessen the plaintiff's loss or injury.